The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show, so here you have the information for Chuck Strain joining us today. And as always, Don Moore and Dan Moore at the Moore Law Firm, moorelaw.com. You can get all this information by going to fox19.com. Just click on the Moore Law graphic. And speaking of graphics, you wanted to give some information to the viewers.
Well, thank you, Deb. Actually, that's true. One of the things that people don't understand sometimes is that somebody that sells alcohol, basically they're given a license to sell a drug, that is alcohol, that's popular in our culture, and there are rules that they have to follow, just like a pharmacist has to follow rules in order to dispense drugs. And a seller of alcohol can be a bartender, it can be a grocery store, it can be a pony keg, it can be a restaurant. There are specific circumstances. If they break those rules, they're responsible to the people who are hurt as a result of those rules being broken. In Ohio, if they are negligent, that is, a negligently intoxicate or serve an intoxicated person in Ohio on the premises, then they're responsible for the harm that's caused either to that person or to a third party. If it's off the premises, that is, the person, the drunk, leaves the property and injures someone, then it's very difficult because you have to prove that the bar knowingly served a visibly intoxicated person. They almost have to admit it. That's really tough stuff. In Kentucky, whether it's on the premises or off the premises, the bar vendor or the alcohol vendor is going to be liable. This is important because oftentimes the drunk driver does not have enough insurance or doesn't have any insurance, and the person who is injured as a result of their bad behavior can be devastated. So often you look back to a vendor. They don't all carry dram shop liability, which is what this is called. But if they do, typically the dram shop liability is going to be $1 million or more, and that's going to be enough to really help the people who are injured or killed.
Okay.
Tough stuff.
It really is. It really is. It's a scary issue. I mean, when people are in a bar, you just don't know what's going to happen when they leave.
What we're talking about today is the criminal aspect, mostly because Chuck has so much experience doing that and helping people who've been charged fairly or unfairly. In our case, if we're representing someone who's been injured or killed, that's a whole different angle, and we want to help the victims.
Okay.
And Don, you probably know too very well that it's a different situation if it's a social host. So if I were having a party at my house and somebody got drunk, it'd be a whole different story than if I were a bartender, right?
Yeah, typically, that's right. Typically, for a social host in Ohio, no liability period unless they gave booze to minors, and then they're on the dime.
Okay. All right. Well, let us go back to the phones. Ken in Kentucky, you had a question about a DUI?
Hi. Good morning. Yes. For those folks that have 2 or 3 DUIs or more, why can't they be charged with a bigger offense? Because they have a total disregard for everybody else, like attempted murder.
That's a good question.
Well, murder wouldn't be an appropriate charge, but there are, in every single state, escalating charges, escalating penalties if you've had priors. As we talked about a little while ago, Ohio has a look-back period that's important for 6 years. So if you've had a prior in the last 6 years, then that really jacks up the penalties. And similarly, if you have had a number of them, if you've had 5 in the last 20 years, that makes it a felony. And once you have a felony DUI, any DUI you have after that is going to be a felony. And when you're in the felony range, we're talking about actual prison time for up to 5 years. So it does get pretty serious. But we don't have, under our Constitution or in our coffers, we don't have enough money to pay to put people in prison and warehouse them for the rest of their lives.
Chuck, although one of the things that goes to Ken's point, if a person is DUI and they kill somebody, they can't be charged with murder, can't they?
I don't think it's murder. That would be aggravated vehicular homicide.
Okay.
Now, for murder, you have to have lots of intention. And for someone drinking in order to kill somebody, I'm going to get drunk, so then I'll run over somebody intentionally. I think that's a little difficult for a prosecutor to prove, and unlikely to happen too.
Take more facts than we've discussed anyway.
Absolutely.
Very good.
One of the things before we go, I know that you had wanted to talk about, there are some attorneys who say never ever take the breathalyzer, never ever do the field sobriety test. You have a little bit different take on some of this.
Well, that's right. Quite often you hear on TV and otherwise, lawyers say don't walk, don't talk, don't blow. Well, you're welcome to take that advice, but that's rather unthinking. There are lots of reasons why that you should take a breath test, for example. The legislature in Ohio and in other states have been making it much more difficult for us to get by. They've increased the penalties if you refuse. For example, if you take the breath test, then you'll have a much shorter driving suspension, and you'll be able to get those suspensions over with quicker and privileges earlier. It may be that it'll hurt your case to refuse, because that doubles the mandatory minimum jail time, and it makes it harder for you to get a deal from the prosecutor and easier treatment from the judge. I'm not saying you should always take the breath test. I'm not saying you should always take the field sobriety test, but you ought to look carefully at the situation. The best time to make that decision is just as you're getting in the car, and you assess your cognitive and your gymnastics abilities. You know how much you've had to drink, and you calculate what your breath alcohol content would be and make the decision then.
All right, great. And I think you wanted to add something to this. We have about 10 seconds.
Well, I don't think we've got enough to cover in 10 seconds. We will save it for the next show.
Okay, Chuck, thanks so much for being here.
My pleasure.
All right, and nice to meet you. And we will see you back here next week when we are talking all about injuries. That's it for More Law for this Monday morning.